Thank you, Mr. Chairman. Good afternoon, everybody. I was asked by Mr. Engel to make a presentation to the board and to the public regarding meeting conduct, call to the public, and board relations with the public. These subjects were discussed at some length in an executive committee meeting recently. The consensus of the committee was that we all needed to reduce the level of emotions and change the sometimes confrontational attitude in board and committee meetings. What I present to you now is my suggested method of improving things. By suggesting improvements, it does not mean that I think anything is inherently wrong with the airport authority or how it conducts its affairs. This is a great airport. The airport authority is doing great things to make it even better. But you know, you can always improve, and that's what we're here about. I also took the liberty of adding some comments derived from research that I did on the subject of civil discourse. The board is hearing this for the first time, and not all of them may agree on everything I have to say. So let's explore just how we suggest improving things. What is a public meeting? It's the policy of the state of Arizona that meetings of public bodies be conducted openly and that agendas contain such information as is necessary to inform the public as to what matters are going to be discussed or decided by the board. The statute provides that all meetings of a public body shall be public meetings, and all persons so desiring shall be permitted to attend and listen to the deliberations. A meeting is a gathering of a forum of the public body at which they discuss and propose to take legal action. What are the rights of the public at public meetings? They have the right to attend, they have the right to listen, they have the right to tape record, and they have the right to videotape. This is going on right here today. The public has no right to speak or disrupt the meeting. And these are statutory rights that are granted by the state of Arizona. Can the public speak if permitted to do so? Yes. The law contemplates a permissive limited agenda item called call to the public. And private parties may address the public body on any topic of concern that is within the public body's jurisdiction. Your jurisdiction is conducting the affairs of the airport. It's not an absolute right, but if any one person is permitted to talk, then any person may have that same right. Where does open call to the public come from? Well, it comes from statute. And you'll note that it says a public body may make an open call to the public. And if it does so, that call may be subject to reasonable time, place, and manner limitations. And an open call to the public is not a public forum. It is not a venue for comments on topics outside of the jurisdiction of the organization. It is not a place for personal attacks on board members and staff. It is not a place for advertising your business, for commenting on pending litigation, or for free, uncensored speech. We have some suggested guidelines for open call to the public. I'm not going to read through all of these, but the speaker should speak up so all men hear. They're encouraged to come to the podium. which during call to the public will be placed over in that corner. Speakers should be respectful in their demeanor. Speakers should not advance personal agendas to the detriment of communication. They should limit their discourse to 15 minutes. They will not carry placards, cameras, or other items of distraction to the podium while addressing the body, or otherwise display them while addressing the body, should they choose to remain in their seats. Speakers should confine their topic to the item listed on the speaker request form, which you'll hear more about later. And they should also understand that not all topics that they bring up can be discussed by the board. What response can a speaker expect from the board? I think you've heard before at these meetings, most of you, that matters brought up at call to the public that are not on the agenda, the board is limited by statute to 3 responses. One is to respond to criticism. Second is it may ask staff to research the topic. And third, the board may put an item on the agenda for the next meeting. Those are the only 3 things that can happen. Based upon discussions that we've had previously and in this room and with this executive committee meeting, it's the board's intent to provide 2 separate calls to the public. The first call to the public is for people to speak on any topic that is within the jurisdiction of the authority. And the second call, and this was something that was requested by members of the public in previous meetings, was to be able, after discussion of agenda items by the board members, to be able to comment before the vote on matters that were going to be decided that day. Persons in attendance who wish to address the public body during the first call to the public on non-agenda topics must fill out a speaker request form to assist with the minute taking and the orderly conduct of the proceedings. The form must be turned into the appropriate staff member prior to the start of the meeting, and staff will announce a final call for speakers cards to give everybody an opportunity to get those cards in. This is the proposed form of speaker card. They'll be available at the desk as you come in. On the back side of the speaker card is some suggested guidelines, reminders of requirements regarding conduct. As I mentioned, no public comment cards are required for the second call to the public, but comments must be limited to those items that are called for vote just prior to the vote and the action by the board. The recommendation is that committee meetings will not have a call to the public, but at the discretion of the chairman, the committee may solicit input from the public on any agenda item. Committee meetings are there to talk about specific matters that come before the committees that are within their jurisdiction. The chairmen are going to be encouraged to do so. It is intended that committee meetings be quite informal, somewhat like a conversation, but with the limitation that any speaker must first be recognized by the chairperson and address the agenda matter at hand and respect and adhere to the directions from the chairperson. I don't know how many of you were in attendance at the strategy committee meeting a week or 2 ago. I think it was an excellent example of what we hope the committees will continue to be and how the meetings will be conducted. And I think there was a great deal of open dialogue, but in an orderly fashion. It's our sincere hope that specific rules of engagement will assist in making meetings more effective. These will changes are not directed at any one person or any group of persons. Basically, they reflect rules of engagement that are in place in other public bodies in Arizona towns and counties across this state. The authority recognizes that there has been some discord among some members of the public and some of the authority staff. We would like to alleviate that discord, but much of the discord has been generated by members of the public. If we are to resume more respectful civil discourse, all must cooperate, and that includes the members of the staff. Continued personal attacks on individuals serve no purpose and will not advance the common community interest that we all have in this airport. Issues have been raised by members of the public and by staff and directors as to whether or not recordings should occur before or may occur before and after meetings. I bring to your attention this statute of the state of Arizona that says that, except as provided in this section, a person is guilty of a Class 5 felony who intentionally intercepts a conversation or discussion at which he is not present. Intentionally intercepts means recording. So what does this mean? For those who may be recording or videotaping, it means that if you record a conversation between two people or more than two in which you are not involved, you may have committed a violation of the statute. So we just want everybody to be aware of that. That is what the law is. It's a one-on-one situation. One person involved in a conversation with another person. Either person can consent to that recording without the other one knowing it. But if you record two people who don't know it, and you're not involved in that conversation, you're committing a violation of the act. The other thing I'd like to mention is that, surreptitious recording, it was a problem. Members of the public have been asking for a greater degree of communication by board members and by staff, more open dialogue, and I think that there's very much an effort to do that right now, and will continue to. But if you sneak around and record people's conversations or their video while they don't know it outside of the public meetings, that's going to violate the trust, and nobody's going to want to participate in any kind of conversation with those who will do that. So we just suggest you govern your conduct accordingly. How do we avoid problems? We just finished talking about rules of engagement and the laws of this state. The third mechanism whereby the free flow of information or exchange of ideas happens is called civil discourse. Civil discourse is engagement in discourse intended to enhance understanding. And if open calls to the public and other permitted communications don't enhance understanding, then the discourse is not civil or meaningful. And in order to have civil discourse, we need to avoid conflicts that ignite emotions and inflame passions. This is Leah Ward Sears, a former Chief Justice of the Supreme Court of Georgia, who put it pretty plainly. We need to, in this country, begin again to raise civil discourse to another level. I mean, we shout and scream and yell and get very little accomplished, but you can disagree very much with the next guy and still be friends and acquaintances. Merriam-Webster defines discourse as the verbal interchange of ideas, especially conversation, Interestingly, the First Amendment of the United States Constitution protects this speech, but it also protects uncivil discourse just as much as it protects civil discourse. Everyone has the right to speak their mind freely, and good or bad, you can pretty much say anything you want about anybody, especially public figures. I think you're all aware of the tragic shootings in Tucson a little over a year ago with Gabrielle Giffords and other citizens. And the only reason I mention that is because arising out of that, there was a huge human cry about civil discourse and the need for more of it in our country. As you might suspect, that event generated a lot of articles and writings, and I had occasion to read a number of them in the University of Arizona Law Review recently. One in particular I felt was pertinent, and that is entitled "Freedom of Speech, Liberal Democracy, and Emerging Evidence on Civility and Effective Democratic Engagement." It's written by Tony Massaro, who is a former dean of the law school, and a professor of sociology, Robin Stryker, who is research director of the National Institute on Civil Discourse. And they had this to say in recognizing protected free speech. Quote, "In short, the very worst distortions that may exist in modern political speech, baseless, vicious, anonymous accusations that favor one side of a debate and can quickly go viral with no time for effective counterspeech, enjoy impressive First Amendment protection. The idea of civility, thus, is not just about the verbal means with which one attacks another's ideas, although it is also about this, but the substantive goals of these attacks. Sharp-tongued debates, ideally, are not just blood sport for television or radio audiences. Rather, they should be part of a democratic process of seeking shared governance outcomes that may be lawfully enacted and peacefully imposed without unduly alienating polluters. Can good manners be mandated? Yes, they may. In 2008, the Fourth Circuit Court of Appeals, in the case of Steinberg versus Chesterfield County Planning, came out with this ruling about a planning commission. The commission has a significant interest in maintaining civility and decorum during the public comment sessions of its public meetings. I'm not going to read the whole thing. You can read that. But the follow-on paragraph to that said, "We conclude that a content-neutral policy against personal attacks is not facially unconstitutional insofar as it is adopted and employed to serve the legitimate public interest in a limited forum of decorum and order." I need to talk for just a minute about Yuma Airport Watchdog website. As most of you know, Mr. Joe Gomez is conducting a campaign against the airport, its director, certain members of the board, against me, and others not part of the authority. It is the airport authority policy that such personal attacks be left at the door when entering airport authority meetings. From a legal perspective, many of the attacks cross the line from free speech to defamation of character because of reckless disregard of the truth or intentional misstatement of the facts. Now, publishing untruths may or may not be illegal or actionable, but it clearly, by any standard, is not the right thing to do. I'd like to illustrate a couple of examples of the untrue statements. Allegations were made against Bill Gresser and his son, alleging improper, unethical, and illegal behavior. That's simply not true. There's no evidence to support any of the allegations. And the records of the authority in detail support that all the activity of their conduct was absolutely appropriate. The website also said that I intentionally misled this board of directors. That also is untrue. I've been practicing law for 45 years. I've never intentionally misled a client in my life, and I don't intend to start with this organization. The camera incident that happened at the last board meeting, on the website it was alleged that there had been a probable cause determination that a crime had been committed. That also is not true. There's no evidence that probable cause was ever established. There was no arrest, no citation, no long-form complaint, no order by the judge. Probable cause is a legal term that has serious implications when you libel somebody by saying, in regards to a crime being committed, that probable cause has been established when it is not. Why am I focusing on this? How does this relate to civil discourse? Because this is incivility in its worst sense. Deliberate lying to damage the reputation of your opponent, failure to inquire or check the facts, or to ask any questions. It is very difficult to engage in civil discourse with a party who conducts themselves so responsibly. We don't know why Mr. Benesch persists in this conduct. It is obvious he is very angry about something, more than just the manner in which the airport authority conducts its business. And that brings us to the discussion about civility versus incivility. And I'd like to turn to another quote by Dean Sorrow and Professor Stryker. And I quote, "Although the emotions of anger and disgust are useful, they, like fear, can operate in ways that skew our ability to draw reasonable, moral, and political boundaries. Anger may be associated with resentment and is, like fear, a sticky emotion that can endure long past the incidents that initially gave rise to it. This lingering effect may cause irrational, grudge-based behavior that can adversely affect civic engagement, insofar as civic engagement seeks to promote political knowledge and understanding. Anger and disgust also are clouding and consuming emotions. Like fear, anger and disgust can absorb the person experiencing them in ways that may crowd out other emotions and thoughts that assist political reasoning. To say that we need our anger thus is correct but unhelpful. We also need anger management." Perhaps the biggest losers in this are the rest of the airport community. You are negatively impacted by the acrimonious nature of proceedings. All of the time and energy and money that is expended in dealing with vitriolic attacks and accusations is time, energy, and money taken away from productive and constructive efforts that actually improve the airport. And that brings me, I'm sure thankfully, to my final quote. Same Law Review article by Professor Orbach. "Our collective well-being depends on productive public discourse and private debates in many ways. Gridlocks and distracting messages do not serve the collective. However, groups of all types deal with opportunism and uncontrolled conduct that cause gridlock and disrupt group deliberation with distracting messages. Thus, groups, such as ours, adopt formal rules of engagement and develop social norms to reduce the value of such opportunism and isolate uncontrolled conduct. Civility and incivility are sometimes proposed as instruments to improve group deliberation." And that's what the authority is doing here, adopting rules of engagement and proposing some social norms to reduce the non-productive rhetoric and distracting provocation. We hope that you will agree. Let's talk very briefly about expectations going forward. The airport authority expects that all parties will leave their differences at the door, civil discourse in its interactions with members of the public, to be treated in a professional manner, to be free from defamation of character, to achieve its goals in the operation of our community airport, and to be treated with dignity and respect. And what may you expect from the airport authority? Transparency and openness, listening and approachability, exercise of due diligence in all responsibilities, that it will abide by all the laws of the United States and the state of Arizona, be firm but fair, and to be treated with dignity and respect. And you certainly will do that. I think.
Good afternoon. I'd like to first respond to what I think was kind of an ambush by Mr. Benesch. I'm not so certain that that was appropriate. There's a venue that a lot of this in-between and this animosity is taking place.
And what's on your form here to talk about?
It says Yuma Airport Watchdog statement on it.
It says Yuma Airport UAW statements.
Okay. Okay, so I'd like to respond to the three statements that Mr. Benesch cited. First of all, the investigation of the assault that happened in this boardroom is ongoing. There was probable cause for the case to be sent to the city attorney. I'd be happy to share those documents. I am having ongoing conversations with the city prosecutor as well as Sergeant Brownlee at the Yuma Police Department. Mr. Benesch's references are completely unfounded. Secondly, with regard to Mr. Gresser, I don't understand the nature of that allegation with there being false information on the website. If anybody ever sees anything that they take exception to, it's been corrected. What we put on the website was that in the course of a board meeting, Mr. Gresser was present during a vote where they were talking about his son selling some land across the street from the airport. Nothing more, nothing less. It's been our understanding that even the mere presence of a board member in the course of a vote or even in the discussion might be a conflict of interest. With regard to Mr. Benesch suggesting that I made a statement or somebody did that he misled the board, that's the first I've heard of that. And so if you'd like to introduce that erroneous piece of information to me, I would be happy to take a look at it. And I know you're snickering over there, but that really doesn't help the process here. And I think that gets to the heart of the disconnect that exists between this board and the public. And while we're on that note, today, pursuant to Title 14 of the Code of Federal Regulations, a multifaceted complaint was filed with the Federal Aviation Administration on behalf of a number of general aviation pilots that cites alleged breaches of grant assurances number 22, 23, and 24, as well as grant assurance number 30, which is a violation of civil rights. And a number of the board members have been served. Everybody will have been served in the next 24 hours. That's what I've got to say. Thank you.